Monday, September 15th. It's 5 p.m. and this is a special meeting, a joint meeting of the Paris City Council and the Paris Economic Development Corporation. At this time, I'll call the City Council meeting to order. And Mr. Grubbs, if you would.
Yes, I also want to recognize it's 5 p.m. We have a quorum present for the Economic Development Corporation, so I'd like to go ahead and call our meeting to order as well.
Thank you. Okay, we're going to move straight on to item number 2, and at this point, I will turn it over to Mr. Grubbs to share his thoughts for the item discuss and receive a report from the PEDC on the completed forensic investigation and take possible action. Mr. Grubbs.
Thank you, Mayor. Tonight we're here to discuss publicly the forensic investigation that was conducted by Deffenbaugh and Associates. Our goal is transparency and truthfulness and to receive the facts, to deal with them and to move forward in a very positive and proactive manner. With that said, I'd like to review the timeline of events that have brought us to this place and time. On March the 10th, 2014, the City Council elected to request that the PEDC initiate a forensic audit of operations following the receipt of an anonymous letter by then Mayor Dr. A.J. Hashmi. The letter questions specifically the value of the loan security or appraised tax value, or both, of a certain transaction involving the PEDC and HWH. Additionally, the letter indicates that there appeared to be a conflict of interest for then Mayor Will Beard to have participated in the negotiation of the incentive agreement with HWH. That was the basis of the letter. On April the 2nd, 2014, the PEDC elected to use Deffenbaugh and Associates to complete the forensic investigation at a cost estimated to be $50,000. We signed a 90-day agreement that began on April the 3rd, 2014 and continued through July 3rd, 2014. Under the agreement, Mr. Deffenbaugh was to provide weekly oral status reports and a monthly written report to the PEDC. For the record, this never occurred. This did not occur. PEDC Board Rebecca Clifford denied having received any oral written reports from Mr. Deffenbaugh at the PEDC board meeting on May the 6th. She again denied having received any written reports at the June 3rd, 2014 joint meeting of the City Council and the PEDC. On July 25th, 2014, preliminary reports were received from Mr. Deffenbaugh. On August the 5th, 2014, the PEDC board met in executive session to discuss personnel issues that were noted in the Deffenbaugh report. Mr. Deffenbaugh was in attendance. And it was then that we were told that the report that we had received was in fact not his final report. On August the 11th, the final report was delivered to the PEDC office by Mr. Deffenbaugh. On August 15th, the final report was made available to the public via public records requests. On September 15th, 2014, obviously that is today, and this is our joint meeting to talk about what is contained within that report. I've asked an attorney representing the PEDC to come tonight to walk us through the more relevant aspects of the report as it pertains to Texas law. So let me introduce him to you now and ask him to step forward to the microphone to share with us. The attorney is Jeffrey L. Moore. He's a partner with Brown and Hoffmeister and has a practice emphasizing local governmental law, economic development, and zoning and land use. Mr. Moore possesses 20 years of municipal law experience as a frequent speaker around the state of Texas on municipal topics, such as economic development for Texas cities, including the Type A and Type B sales tax, Chapter 380 agreements, tax abatement agreements, tax incentive financing, the Texas Open Meetings Act, and the Texas Public Information Act. Before joining Brown and Hoffmeister, Jeff was an assistant city attorney for the city of Austin for more than 6 years. And he spent 4 years with the Texas Attorney General's office as the head of the Municipal Affairs section. Currently, Jeff assists the Texas Economic Development Council, the Texas Attorney General's office, and the State Comptroller's office with Type A and Type B sales tax training seminars required by the Texas legislature. His areas of practice include economic development, government contracts, land use and zoning, state, and governmental law. And with that, Mr. Moore, we welcome you tonight and look forward to your report.
Thank you, Steve. Good evening, Mayor, Council. Appreciate the opportunity to be here, Board as well. There's a number of issues I want to cover tonight. And I've got a handout for the Board and Council and a few extra copies. And the PowerPoint's going to refer to some different questions. Those questions are covered in the paper. What I would note is that over 14 years, I've been dealing with the Type A, Type B sales tax issues. I've done the training over a number of years, and I've seen issues like this come up in several communities, and had come in and help explain what the law provides. And so that's what I want to do initially, is kind of go over the statute and cover the statute, cover the approval process. Because what I saw in the report, a lot of it is a discussion about lack of policies and procedures. What I would add is state law has already addressed all that for you, the policies and procedures. The Type A sales tax is what you have. It's a dedicated sales tax. It can only be spent for dedicated reasons. Those reasons are set out in state statute. There's an oversight process where the board has to approve expenditures. City Council has to approve expenditures. You have to have written agreements. And so state law has already addressed a number of the concerns. And so, part of the report talks about a lack of policies and procedures. And I would suggest that you've already got them. It's in state statute. And with that, I'd like to, kind of cover real quickly. And I stress that the first part I'm going to cover pretty quick for you. I know most of y'all understand that the Type A, Type B sales tax. And hopefully this works. Okay, I'm getting no response on the keyboard. If I may, I'll just, first of all, I want to talk about the issue of oversight. Let me back up and just talk about the sales tax training seminars, and that's the first slide of that paper. In that, a number of years ago, this is back in 2001, a number of EDCs were looking at, they wanted to see criminal penalties put into the statute. They'd seen some misuses of the Type A and Type B sales tax, and so there was a push for criminal penalties. And at the time, the chairman was Jim Solis, who's down in the valley, he's chair of the House Economic Development Committee. He had seen some training put on by the Attorney General's office and the State Comptroller's office. And so what he authored was a bill that would require training on the use of the sales tax versus any sort of penalties. And at the time I was at the Attorney General's office, I was charged with coming up with the training seminars, working with then the Texas Department of Economic Development, that agency, as well as the Comptroller's office, to formulate the training seminars that were going to be used around the state. I'm still doing the training today. They've hung on to me. But the training, when we started up the seminars, the initial concern that most cities had when they come to the seminars for training was the oversight. And what I can stress, it's a local issue. The sales tax is a local issue. Voters voted in. Voters can vote it out. It's not for the Comptroller's office to investigate. It's not for the Attorney General's office to investigate. There is, the District Attorney's office. If there's some criminal wrongdoing, they can investigate. They can ask the Prosecutor's Assistance Division within the Attorney General's office for help. But by and large, the sales tax is a local issue. The training, every 24 months, somebody from the city, basically the way it's worded, one person from the city and one person from the corporation is supposed to do the training. The paper that you have in your packet, that's the materials that is used for the training. And so some of my slides are going to reflect questions that are in that paper. And that paper, further explains some of the issues. What I'd noted that there was some push for, maybe the Attorney General's office or the Comptroller's office to review. What I would note, on this slide gives you the area where the Attorney General's office has oversight. They can, if you hire a third party to do business recruitment and you don't have a written contract for that business recruitment effort, the Attorney General's office can go after the EDC for failure to have a contract. It's a civil penalty. The fine could be up to $10,000. There's no criminal penalty, and I would say the Attorney General's office has never had to, pursue any violations under that section. It's a relatively new section. The other areas, that they're supposed to participate in the training, and that's the extent of the Attorney General's oversight over the Type A or Type B sales tax. They do issue, over the years, they've issued a lot of Attorney General opinions addressing the sales tax because the statute's very complicated and it's not the best worded. And so over the years, I think they've done almost 30 Texas Attorney General opinions addressing different types of expenditures. And so you'll see a lot of Attorney General opinions issued on various sales tax questions. But that is the extent of the Attorney General's oversight. The comptroller's oversight is limited to, to the administration of the sales tax. The retailers remit the sales tax. It gets, goes to the comptroller's office. Comptroller's office hangs on to it for about 6 weeks, remits it back to the city. The city's supposed to promptly turn it over to the Economic Development Corporation. So that they do a lot of the administrative stuff. If you have an election, you got to report the election to the comptroller's office. And so they know when to implement the new rate or the different rate. They also have oversight over the sales tax training, failure to take the training, and then also there's an annual report due every February. That's you have to get that report in. There's a $200 penalty for failure to file the report. There again, my understanding, the comptroller's office has never had to impose that penalty. But that is those 3 bullet points. That's the area of oversight for the comptroller's office for any sort of sales tax issue. Both the Attorney General's office and the comptroller's office, they have to be able to point to a statute. They're very, very much like a county. They've got to point to a statute that gives them the authority to act. And so without that specific statutory authority, these are the areas where the comptroller and the Attorney General's office can address, sales tax issues. Again, most of it's going to be for any sort of criminal violation. That's with the district attorney's office. And the district attorney's office can ask for assistance from the prosecutor's assistance division within the Texas Attorney General's office. Again, I want to kind of go 10,000 foot level here real quick on what can you spend money on, because within the documents I saw, I'd seen where it's only primary job employers versus, there's job training, there's promotional expenditures. And so just real quickly, I want to cover, what you can fund. And on this slide, I've given you the statutes that under the local government code, it's under Chapter 501 of the local government code. The PEDC for primary job employers, like manufacturing and industrial facilities, you can fund pretty much anything. You could provide land, buildings, equipment, infrastructure. You could provide monies for a primary job employer. And so that's a laundry list for those type of expenditures. Here's a whole list of expenditures where they do not have to be primary job employers. It could be a retail, it could be a Home Depot, it could be a Lowe's, it could be a restaurant, that you can pay for job training, you can pay for targeted infrastructure. I'm going to say back in, it was 2003, Representative Mark Homer authored the bill that allowed for this targeted infrastructure provision. And there the board, they can provide, pay for the, water, sewer, electric, drainage, streets and roads for business development. It does not have to be a primary job employer. It does not have to be a manufacturer. If it does business development, they can fund those sort of targeted infrastructure. This is the laundry list for the infrastructure that could be funded by the PEDC. And the way the statute's worded, it talks about, found by the board of directors to be required or, required or suitable to promote or develop new or expanded business enterprise. So it's business development. It could be primary jobs, but it doesn't have to be. And if the PEDC wants to provide that assistance, They can pay for the streets and roads. Again, this laundry list: rail spurs, water, sewer, electric, gas, drainage. And so that's, again, it's not a primary job employer. It doesn't have to be. There's some other provisions that I won't cover, but what you'll see from this slideshow, there's a number of statutes that say what you can spend the money on the Type A sales tax. So state law has already addressed that. This is a provision for those within 25 miles of an international border. I think 2 years ago in Mesquite, we had somebody raise their hand and they said, well, does that include Oklahoma? And being I'm a Longhorn fan, I said it should, but it doesn't. You know, this is for those on the border with Mexico. And so there's a provision for those in the valley. There's a provision for Hidalgo County, very specific. This last session, Port Arthur had 2 bills passed that allows them to do certain type of sales tax expenditures for Port Arthur and those along the Gulf. So obviously those aren't applicable here. And so the state law has already addressed what you can spend money on, and those are projects. Then what you have, you can spend money for promotion and then for job training. And for promotion, there's a statutory limits, 10% per year. What I've handed out is the Texas Attorney General opinion that addressed that issue as well. It's a Greg Abbott opinion, GA 86, issued in 2003, and it dealt with the city of Hutto. And Hutto there, their mascot is the hippo. And the question presented was, could they install basically I guess my understanding, the world's largest fiberglass hippo on the school district, on the high school grounds, and would that be a permissible promotional expenditure of a Type A corporation? And that's what the PEDC is, a Type A. And there was a number of issues there. And you know, so is that building this fiberglass hippo, is that a promotional expenditure? And what the Attorney General said, it was one interesting, the Attorney General did not say no. So that the Attorney General said that's for the Board of Directors to make that decision. And it's subject to review by City Council. City Council could approve or disapprove of the expenditure. And then they looked at, what is promotion? Is it advertising in the paper? Is it going off to ICSC? Their issue was, is it, the largest fiberglass hippo? Is that a promotional expenditure? And what the opinion noted, I think it's on page 2 of that opinion, and you do have a copy of that opinion. It says any sort of promotional expenditure is supposed to publicize or advertise the city for business development. So if you're advertising or publicizing the city for business development, that's a promotional expenditure. And then lastly, the issue was about 10%. It's an annual limitation, but given fiscal years, you have an unexpended portion for promotion. You could roll that over into the new year, and for the new fiscal year, allocate another 10% for promotion, and then still spend the unexpended portion. And so that's promotion. So you've got projects promotion, then you've got job training. And the PEDC can pay for job training. It's basically what the statute provides is that the business entity, or uses the term business enterprise, has to commit in writing, or it has to create new jobs that are going to pay the prevailing wage for that occupation in your area. If they're going to commit in writing to do that, then you can pay for the job training. The job training does not have to be a primary job employer. It could be retail, it could be a manufacturer, but it could also be retail. And so that's what the job training requirement under the statute. And with that, I'm going to kind of turn into the oversight. For the audience, these numbers up here correspond with the paper that's been provided to the board and council. Again, that's what's used for the training. And again, I want to just quickly cover the oversight that's provided by state law. In question 23 of the paper, what it provides or raises, can an EDC just gift or grant monies? And the answer is no. You have to have a written contract that they refer to as a performance agreement. The performance agreement is supposed to have the capital investment made, the jobs to be created or retained, and some sort of penalty provision. Those are the general requirements for a performance agreement. that, you know, if a business says they're going to create 10 jobs, they only create 5. You get to decide what that penalty is, but there should be some sort of a, you know, clawback provision within, you know, within that performance agreement. Business recruitment, and, you know, I spoke about that earlier on the oversight. If you're going to hire a third party to do business recruitment, then basically you just have to have a written contract approved by the board. Again, if you're going to pay that recruiter anything of value, there needs to be a written contract. The Attorney General's office has this limited oversight. They can go after a penalty up to $10,000. They can bring that action in Lamar County, or they can bring it in Travis County. Now, who administers and oversees the Type A or Type B sales tax? It's the nonprofit corporation. When you vote in the tax, when the voters voted in, then the next step is to create a nonprofit corporation. You get articles of corporations filed with the Secretary of State. You've got a board of directors that serve on the board. Council, you get to appoint them. Council, you can remove them. But the board of directors oversees the sales tax. But ultimately, you got to get City Council approval for expenditures as well. So it takes the board approval and council approval. You know, 49 here, does City Council have to approve expenditures of Type A, Type B sales tax? And the answer is yes. City Council, you get to approve the expenditures of the board. And I would say over the years, this is probably where we get more questions right here, and I think this is your issue. This is the center of your whole issue here, is question 49. And basically, it's the oversight over the EDC. What the statute provides, and it uses the term the unit, it says the unit will approve all programs and expenditures. That's defined to mean City Council. That as City Council, you get to approve all programs and expenditures. It doesn't say when or how. Could it be during the budget process? Yeah, it could be during the budget process. If the EDC lists out all these projects and you approve them, that could be the approval. I know of one corporation where if the EDC wants to buy a box of pencils, they want that the council wants that as an agenda item. You could do that too. You have the approval process. I know EDCs that put into their bylaws. And as council, you get to approve the bylaws. You approve any amendments to bylaws, and what you could put in is some dollar amount that everything under a certain dollar is deemed approved. We got enough on our agenda. We don't want everything over that amount. You got to bring it to us. My understanding is you have that currently with a 400,000 limit. I mean, you can do that. But that's all state law says. It says City Council gets to approve all expenditures. It doesn't say when, how, and so that I think is really, from my humble opinion, that's the issue here: the approval, the oversight on the sales tax. The Attorney General opinion here notes that again that GA 86 that your approval is also over promotional expenditures. You can approve or disapprove of promotional expenditures as well. On 49 here, down on the coast, Port Arthur, there's an opinion, GA 264, that was issued a number of years ago. That was City of Port Arthur. They're a Type A sales tax as well. And basically the issue there was City Council had funded an agreement with a Target store, but the board had never approved it. And the Attorney General noted that City Council, you can't do a project on your own. It takes the board approval and council approval to do projects. And also lastly, what I would point out is all the statutes that I referenced at the beginning of the PowerPoint, most of them have wording that says, found by the board of directors to promote new or expanded business development. In that same opinion, and there's been prior opinions, what the Attorney General's office has noted is that it's for the board of directors to make decisions. Is this economic development? Is it going to promote business development? The board gets to make that decision, and then it's for council to approve or disapprove. And so if the board makes that initial determination, and I saw, in the report it talks about, well, somebody else should have paid for it. Well, again, it's for the board to make those decisions, and then council as oversight, you can approve or disapprove. And so that's what state law provides. Lastly here, I mean, the meetings are subject to the Open Meetings Act. The public can attend, that, the meetings should occur in the city limits. And with regard to, conflicts of interest statute, there's an Attorney General opinion out there that noted that the conflicts of interest statute does not apply to a Type A or Type B corporation because they're not a local public official. They're very much attached to the hip of the city, but at the same time, they're a nonprofit corporation. And so as a nonprofit, the conflicts of interest statute doesn't apply to them, but I know that, bylaws, articles of corporation, or, city ordinance can impose that requirement, but state law does not impose that. And then I guess lastly, just, are your meetings subject to a public hearing requirement? And for Type A's, there's no hearing requirement. There's two exceptions, not worth covering here. Public hearing wasn't an issue. But, I mean, so that's the oversight. And so, again, throughout the report, what I saw is, there's no policies and procedures. State law has already done that for you. Now, could you address a travel policy? Could you set up, per diem for certain expenses? Yeah, you could do that. But, state law has already addressed a vast majority of what is required under the statute. Shifting to the report, I hope I'm doing good on time here. The report noted 7 issues. I'm going to try to cover them real quickly. On page 5 of that report, it noted that the report should be destroyed when the information is no longer needed. I would stress don't do that. I mean, it's you're subject to the Public Information Act and records retention schedules. Looking at the State Libraries and Archives Commission records retention schedule, I didn't see anything directly specific to this type of report. But for agreements and leases and those sort of documents, usually you keep them through the term of the agreement and then for 5 years thereafter. So at a minimum, you probably need to keep this 5 years. I'll let Kent advise you on that. But this is a completed report. Generally, completed reports are public, and there may be driver's license numbers, social security numbers you get to redact, but a completed report is going to be public generally. And you got a records retention schedule to deal with. Number 1, the PEDC financial review, the lack of fiscal oversight. I just covered all that in the earlier slides. I mean, you could adopt a travel policy as council, or adopt a travel policy on what's expenditures, what are good expenditures. Tracking of funds, expenditures must be required to account for the use of public funds. Again, state law says you have to have a written agreement. And if you got the written agreements, that's what state law provides. PEDC was paying for expenses which should have been incurred by other entities. And I've noted a couple of the expenditures there. Again, these promotional expenditures, the incubator, grand opening session, and promotional expenditures for advertising. Again, consistent with that Attorney General opinion, if it publicizes or advertises the city for business development, PEDC statutorily can pay for the promotional activity. Whether somebody else should pay for it or not, I mean, that's a judgment call, but the statute leaves that to the board to make the decision, and then it's for council to approve or disapprove. Funds provided to Lamar County Chamber of Commerce, and it said, potential fraud, waste, and/or abuse. Again, the chamber, there's actually a specific statute. It's 504.102 of the local government code that says that the PEDC can contract with any, corporation to carry out the objectives and duties of the EDC. And a number of cities have a joint chamber EDC office. And especially smaller communities, they'll have maybe a joint chamber and EDC office. And what the statute says is that, Type A or Type B, they can fund, those sort of private entities, a chamber, provided they're doing provided they're doing EDC stuff. And so, on the previous slide where it said, they're funding the Lamar County Chamber of Commerce. Well, if they're doing EDC stuff, you can fund it. The Conference on Shopping Center Developers, ICSC, and I guess the purchasing of incidental expenses. ICSC, I would have to say, is a big conference. I've never been, but none of my clients will ask me to go. But I would say there's probably about 50 to 75 cities and EDC, Texas cities and EDCs that go to it every year, and that it's a big event. I've got a list of this year's exhibitors and attendees. You got 7-Eleven, AT&T, Bass Pro Shops, Bed Bath & Beyond, Chick-fil-A, the Container Store, and I'm just reading highlighted a few of them. CVS, Dick's Sporting Goods, Fossil, HEB, Hobby Lobby, In-N-Out Burger, Jack in the Box, Kohl's, Kroger, McDonald's, Nordstrom, Panera. I mean, I could go on and on. If you want to get somebody to come to your community, they're probably going to be at this conference. And so, the AG didn't say no to the world's largest fiberglass hippo as a promotional expenditure. I would say this is probably a better fit for promotion. If you're going out to that conference and you're publicizing and advertising the city of Paris to get companies to come to you, instead of flying to Minnesota to visit with Target or somebody in New York, you're going to find them all at that conference. And you got some Open Meetings Act issues to deal with, but what I've seen in communities that works real well, given the Open Meetings Act, I would say you don't want to take a quorum out there, but when you have maybe 2 council and 2 EDC members going out there and working that conference, setting up interviews, setting up meetings with all these different corporations that are there, that is more bang for your buck than flying all over. But there's a lot of EDCs that attend that conference, or the certain receipts. I mean, I guess everybody could have better receipt keeping and submission of receipts, I imagine. But ICSC, a number of cities, number of EDCs go to that annually, and it leads to a lot of good prospects for them. And that again, just could you attend a conference? Again, the Attorney General said, is it going to publicize or advertise the city for business development? That's your test. If you think it's going to do that, then you could pay for that, sort of conference. The Red River Valley Veterans Memorial, there's a note in here, bookkeeping error gave every appearance that the PEDC was gifting public funds in direct violation of the Texas Attorney General's opinion 97-61. That opinion was a 4A or type A sales tax opinion, dealt with City of Pampa, dealt with the Clarendon College. Could the type A fund the Clarendon College? And the Attorney General said no, that it didn't fit the statute back then. And the way it was framed, it said, can we gift monies to the Clarendon College? And the opinion noted that, hey, you're using public funds, so there needs to be a written contract. And that's all it says. It doesn't say it's criminal if you didn't have politically that's a problem if you don't have a contract, but it's not criminal. And that was one of the main reasons that the Type A, Type B sales tax training seminars got implemented a number of years ago. It was to train EDCs on that. You need to have written contracts. You need to have the approvals. But it's not criminal. I understand the political ramifications, but again, that opinion, nowhere in that opinion does it say it's a criminal violation not to have a contract, written contract. It just said that you need to have written contracts. The Veterans Memorial Comedy Benefit, again, this is there's some notes on that. Again, promotional expenditures, I've already touched upon that. That if it's going to publicize or advertise a city for business development, could you fund this, that, and the other? Board gets to make the decisions, and then council can approve or disapprove. The chamber event, again, the RRVVM chamber event. There was a note on that under that said question that expenditure. Again, Type A corporations can contract with business entities that are conducting business activity. It could be, the chamber could be doing the advertising for the community, and that's where I see it a lot around the state. And the EDC could pay for the chamber's advertising activities, and so that's doable under the statute. Although there were no policies and procedures in place regarding expenditures, PED staff had a fiduciary responsibility to ensure the best use of 4A, now called Type A, development funds. Well, that's not exactly accurate for the staff. It's really for the board. As council, you get to make decisions. You set the policy, and then it's for the staff, the city manager, to go implement the policy, to go execute. Likewise, the board. It's for the board to make decisions. Do we want to fund this and the other? Then the staff go carry it out. Again, the board, council, you get to approve the expenditures. Under that section, perhaps a travel policy, maybe some per diem policy. I know when I was at the state with the Attorney General's office, through the state contract, we had a list of hotels that we could stay in and could not stay in. For South Padre Island, there's a couple hotels I could not stay at, but I could stay at the Sheraton. I could stay at the Howard Johnson. Actually, that's a pretty nice hotel. And they had a list of where you could and could not stay, and so that maybe that's something to consider. I'll leave it at that. Again, you have to have written agreements. Number 3, records and accountability practices. There again, state law's already addressed all this for you. You got to make the expenditures consistent with the state statute. Council gets to approve or disapprove. You got to have written agreements. It takes both approvals, the city council, and the board and city council. There appears to be no legitimate purpose with regard to economic development. That was, a reference within the report. And again, what I've noted here, that one of the opinions, there's several opinions that address that note. Really, it's for the board of directors to make that decision. Is this doing economic development? Now, it could be subject to judicial review. It'd be an abuse of discretion standard of review. But whether something's, that could be a nebulous term. What's economic development? And that's where the EDC gets to make those decisions. But again, you have oversight and could disapprove of expenditures. Intentionally or fraudulently commingling, funds. I'm not aware of any statute that deals with Type A or Type B sales tax on that issue. Now, I would add that Type A, there's the you got promotion. You're limited to 10% on promotion. So a lot of EDCs will set aside 10% for promotion, and then everything else is in a different bucket, for lack of a better word. But you're limited to 10% for promotional activity per year. And so, there I would just, separate out the promotional expenditures. Again, all your expenditures have to be consistent with state law. Projects are, job training. The Diversity Initiative Program basically noted it was, kind of a good program, worked, yet there was an $8 shortfall. And I would just say, I guess there will always be better accounting, better bookkeeping, but that's not fraud or waste or abuse. I mean, fraud is an intent to deceive. I guess a mistake in accounting is something totally different. Job training, again, if it's job training, you can pay for job training, and I've given you the statutes there. Basically, the business entity has to commit in writing to increase their payroll or create new jobs that are going to pay the prevailing wage for that occupation in your area. If they're committed to do that, you can pay for job training. HWH agreement. There was a note in there. It said information revealed that there existed a lack of fiscal oversight in the PEDC. And again, that's kind of what I saw throughout the report. State law has already addressed that oversight for you. It takes board approval, council approval. You need written agreements. The conflicts of interest issue that's noted in the statute, or noted in the report, that's Chapter 171 Local Government Code. Basically, it doesn't apply to all conflicts. It only applies to very specific conflicts. It's where the person might have a substantial interest in a business entity or real property. And that's further defined. It's usually 10% or more of your gross income from that business. That's going to be a substantial interest in a business. For real property, it's having a legal, equitable interest, $2,500 or more in real property. That's going to constitute a substantial interest in real property. What the statute provides is if you have that sort of conflict, then basically three things you have to do, and I'm sure this may have come up before and you've done that, that you file an affidavit, you abstain from voting and discussing it. That's what the statute provides. It provides, let me back up. In the report, it noted it's the responsibility of the contracting entity, the PEDC, to determine what action to take to address the possible ethical breaches by those involved. I would note if there is a violation, it's a Class A misdemeanor. That'd be for the district attorney's office, not really for the PEDC to review. It's for the DA. If there's a criminal violation, that's for the DA's office to look at. I would note, most of this we're talking about from 2010, and I'm not saying there was a violation. I'm saying if there were, the statute of limitations is run. It's a 2-year statute of limitations for a Class A misdemeanor. And furthermore, I saw within the documents I reviewed that a conflicts disclosure statement was filled out. And it was under 176, but that there was a conflicts disclosure statement filled out and submitted to the EDC. There's a statement within there, Gilbert participated in the contract negotiations with HWH, as this was part of his official duties as the executive director of the PEDC, may have been fostering a private relationship with HWH. And, I guess, I'm not aware of non-compete clauses for cities. Hopefully executive directors are visiting with all businesses in the city to then say you can't go work for any of them if you leave. I don't know if cities that do that. What you could do is maybe do a revolving door policy. I've given you an example there. This deals with city utility boards. That basically what that provides is that the member who leaves the city or the board, that I think the statute says 2 years in this instance. You can't come in front of the board for 2 years after you leave. And so, you could do some sort of revolving door sort of policy. I just haven't heard of a non-compete in the city context. Hopefully most executive directors for EDCs around the state, they're visiting with all the businesses. The HWH agreement review, expenditures for operating and maintenance expenses not to exceed $7,500 per occurrence. I understand that's been removed. That'd be one of my recommendations. If it had not been removed, would be to remove it. But again, if somebody has the approval and they're making expenditures consistent with that, all expenditures need to go through the council or go through the board and go to council for approval. And again, the approval can be any number of ways, via budget, what have you. Number 6, Red River Region Business Incubator Review. Again, the kind of general theme, lack of oversight, fiscal oversight. Again, state laws already address that. You need written contracts, need board, council approval. And if I were to ask, how do you fund it? Could you fund an incubator project? I would say, yeah, you could. You're limited, given that for primary job employers, you have a lot of latitude. If it's a manufacturer, you can do a lot of things. If it's not a primary job employer, you're limited. I know the emphasis under this project was for manufacturing, and if it is under that 501.101, you could provide monies for manufacturing. You could provide land, buildings, equipment, facilities, targeted infrastructure as well for a manufacturer. You could pay for job training expenses. If the incubator had job training expenses, you could pay for it. Under the targeted infrastructure provision, again, that was a number of years ago, 2003, was that House Bill 2912. Representative Mark Homer authored that bill to do certain targeted infrastructure, but it only has to be business enterprise. does not have to be a primary job employer. So there's any number of statutes that could have gone under to do that sort of project. Regenovate, if I've said that correctly, project number 7. Again, business recruitment, third parties. Now that statute applies when you go out and hire a third party to do business recruitment. You got to have a written contract. Part of that, I guess, report said, well, that's really for the board of directors to be doing that. I mean, usually the executive director is doing the business recruitment, or if you hire a third party, you're going to have a written contract. And by the fact that they've got a statute here that says you go out and hire a third party, kind of, suggests that that's very common to hire third parties to do business recruitment. The fact that it didn't pan out or, nothing came of it, those decisions are left with the board to make, is this going to do economic development and then with council approval, maybe a little Monday morning quarterbacking, that didn't get the results that it was needed, but is it business recruitment? If so, the board can pay for it. They need a written contract. Lastly, and I apologize, I guess going about 45 minutes is about what I planned. The recommendations, I mean, and some of them were very similar to what the report, Mr. Deffenbaugh's report indicated, and I've just got really 5 of them. I mean, you need written performance agreements. If you didn't have them, it's not criminal. You need to have them. And what I would suggest is, what I like to do as an attorney when I draft them, I prefer to have it as a reimbursement basis. The developer says he's going to do all this stuff. He's going to build a street. Well, I like him to go build the street and then give me the receipts for it and then reimburse them. So where you can do it on a reimbursement basis, I'd recommend, performance agreements on a reimbursement basis, not giving them the money up front and hoping he builds the street. Have him go build it and then get us the receipts and then, give them the reimbursement. Get, board and city council approval on expenditures. I would perhaps amend your bylaws, adopt policies addressing travel, maybe any incidental per diem, have a per diem for, travel. Promotional expenditures, keep those separate, segregate those because you're limited to 10% for promotional purposes. And then lastly, dealing with the non-compete issue, maybe a revolving door policy might be, if you got people that leave and then are coming back in front of you asking for stuff, maybe say you can't do it for a year or 2 years. And those are generally, I didn't see anything criminal in here. I saw leaps saying and it usually used the word potential for fraud, waste, and abuse. Well, the fact that some expenditures may not have panned out, maybe you could say it's waste, but that it didn't work, it didn't achieve the objective, but it's not fraud. And so I just, could there be better bookkeeping? Yeah, there could be better bookkeeping. But the fact that you have an entry that's one-off on a line item and just it's in the wrong category, that doesn't make it fraud or waste or abuse. And with that, I'd be happy to try to answer any questions that you have.
Okay, at this time we'll open it up for questions. I realize they may come from all directions, so be patient while we recognize. Anyone like to start?
Can I ask?
Sure, go right ahead.
I want to address one issue later, if with the mayor's permission, but I do have a question.
Yes, sir.
My first question to you is, when you're talking about 4A and 4B, you combine most of that. Tell me then, what is the difference between 4A and 4B here? You almost counted every expense as a doable expense under 4A. You could put infrastructure, you could do roads, your board could almost approve anything.
That's a good question.
So why 4B then?
Okay, 4B was written for the city of Arlington to do the ballpark in Arlington a number of years ago. And within that statute, they said you could do public parks, that you could do different sort of quality of life issues. So they have a different statute. They have a different chapter. It's Chapter 505 of the Local Government Code. And it says you can do all these different expenditures. And so that's probably the main difference. Type B also has some procedural issues that they have to deal with that Type A does not have. Type B has to publish notice of the projects. If they're thinking about doing a project, they got to put it in the paper. And then they have to wait 60 days before they can fund that project. And basically it allows the voters to get a petition together to object to that project. And if they got the number of signatures needed, 10% of the registered voters, then they'd have to have an election to do that project. And it was all written for the ballpark in Arlington, is this statute. But procedurally, Type Bs have some procedural steps they got to walk through. That they generally, there've been some revisions over the years, but generally have to hold public hearings on projects. The board of directors are a little different. For Type A, there's no residency requirement. For Type B, there's a residency requirement. For those under 20,000 in population, you got to be a resident of the city or the county in which a major portion of the city is located, if you're in more than one county. For over 20,000, Type B, you got to be a resident of the city. The directors, it's 5. You have to have at least 5 for a Type A board. It's 7 for a Type B board. So those are kind of the major differences. There's some different projects Type Bs can fund that Type A can't. But I would say the main one is the provision for the ballpark in Arlington, to do professional amateur sport facilities, or to do public parks.
Okay, so in other words, you don't have to have creation of manufacturing jobs specifically under 4A.
For some provisions, that's correct. You do not have to do primary jobs. And that was a big change under House Bill 2912 a number of years ago, where they inserted a requirement that you have to create or retain primary jobs. They didn't put that in all the statutes. They put it in a lot of the statutes. So for a lot of Type A expenditures, it's primary job employers. But the provision now, this 501.103 provision, the targeted infrastructure, that does not have to be for a primary job employer. It just has to be business. If it's going to do business development, you can do targeted infrastructure.
Okay. I'll have another question for him when we get to the specific report, if you don't mind.
To the specific report?
Yeah.
Okay.
I'll do it later on.
Anyone else have any questions at this time?
Yes.
Sue?
Looking at 23, says, can a Type A or Type B corporation grant or gift Type A or Type B proceeds to a business entity without a performance agreement? And you say, no.
No, you have to have written agreements. That's correct.
Then I bring you case in point, the R3BI. That was a considerable amount of money, in excess of 10%. How did they achieve that without a contract?
There should be written agreements.
So that would be a violation?
There's not a penalty for it, criminal
penalty.
penalty.
I'm not saying criminal. I'm saying that would be a violation.
It would be inconsistent with the statute, correct.
Okay, well, I'm submitting that did happen.
Okay.
And I have the numbers to prove that it's considerably more than 10%.
Well, promotion is limited to 10%, but any sort of expenditure, project, job training, or promotional activity should have a written agreement. Since you're dealing with public funds, there should be a written agreement approved by the board, approved by the City Council.
And so what relief is provided for that since it didn't occur?
Well, what state law has provided over the years, there have been a number of court cases that deal with expenditures and setting aside a standing issue on, say a taxpayer wanted to bring suit. What courts have done or said is that you don't make them repay the impermissible expenditure. It's moving forward. A court could prohibit future impermissible expenditures. That's the remedy. When there's, if somebody were to challenge an impermissible expenditure, it's not, you don't repay the past. It's moving forward. You could stop the future expenditures.
Okay, what would happen to the assets of that particular entity?
Which entity?
The Red River Valley, R3BI?
Well, I guess it would depend on, I guess you're talking about deeds, or it would depend on
Well, it's property and
who's
monies.
got title.
Property and monies. What should happen to that?
That, I can't address, how that should be disposed of. I mean, that could be, just for sale. Whoever, if it's an MLS, whoever puts in a contract that's accepted by the seller.
Well, it doesn't come back to the PEDC or the city council or the city?
Did the PEDC have a lien?
No, it was purchased by our taxpayer money.
No, I mean, unless
So
they
it
had
just
some
goes
sort.
out anywhere?
So if they had some sort of lien, yeah, they could get, repayment of the lien, but otherwise, no.
What about existing monies in bank accounts?
Well, I guess you'd have, if there was that sort of thought to bring a lawsuit, I mean, you could bring a lawsuit to, potentially recover monies that are owed if it's owed under a contract.
But there was no contract.
Correct.
But in section,
There was no
wait,
signed contract, is that correct? Ms. Lancaster,
Yes, sir.
was there a sign?
No, there was
There
no
not
sign,
a signed
not a
contract.
signed
There was a
contract.
A contract.
You don't have a
Pardon me?
contract if you don't have a signature, I'm sorry.
I understand that. I certainly understand that, but what I'm asking is what is the remedy if the contract was not signed? And what monies were expended? How much money was expended?
There may be some equitable arguments that could be made to say, that you have a contract, I mean, it's an argument that, if there's detrimental reliance arguments that could be raised, I mean, you're getting into equitable issues to raise, but, yeah, I mean, obviously, it's better to have a signed contract.
How much money was given to RB3I and how much R3BI, and what was it used for? Do you?
Are you asking me?
Yes.
Well, it was used for just about everything. It was to pay Hank Bedke's salary per year, even though he was a contract employee of PEDC. It was to buy furnishings. It was to do build-outs. Most of the first year, it looked to me like it was just feathering their nest.
And I would say you want written contracts.
Absolutely.
Yeah.
I'm saying there was no written contract, and so there was no oversight. And I say that's a severe waste of taxpayer money.
weren't those monies approved by the board and the council?
Not the council.
May I answer that question? Over the 3-year period, there was approximately $400,000 given to R3BI. Part of that was put into a line item on the budget for a certain amount, but a lot of it was in excess of that, where they paid advertising, they paid for grand opening, they paid for running a type of, I guess I'll say just about anything. But the thing about with the accounting part, if you looked at where they were, the line item budgets were not, there are other expenses put in those. So if you go through and look at R3BI and just look at the exact line item, there were much more throughout. It may be under new industry, it may be under existing industry, it may be under global recruiting, rural innovations, just anywhere through there where they just need to stick the money. And I guess in that way that if you look back at that, you could say it was fraudulent because those were not the line items that these expenses should have been put in. So I guess it's one way of looking at it. Because I was at the conference that you gave back in 2013, and I asked the question, could you give money to another organization? And you told me, and your answer, it was one of the question and answers, and which
Okay.
you would not have known that,
Yeah.
would not have been from me. I mean,
Yeah.
it was just given from the audience. And your answer then was no. And
Yeah.
I guess that's what you're saying
That's what I'm
now
saying
too.
here.
You can't gift, but in the Attorney General's opinion, when you're talking about Pampa and you cannot give the money to the junior college, what happens if Pampa just gone ahead and done it?
I mean, if they did, the Attorney General would have said you need to have a written contract. You can't gift public monies, that there needs to be a written contract. But at the same time, there's not a criminal provision.
So you really don't even need Attorney General's opinion, you just do what you want to do, which is kind of what we do.
Well, no, I mean, you have a political issue, and that's, voters can vote it in, the voters can vote out the sales tax if they think there's misuse. It's a local issue, but
So what is the remedy, though?
the remedy is moving forward, have written contracts. And, make sure you follow the approval process. That, you know,
I think there's another remedy. You simply do away with this useless organization.
you know, that,
Mr. Moore, you'd
Yes, sir.
agree with me that one lawyer can look at a set of facts and come to one conclusion. Another lawyer can look at a set of facts and come to another conclusion. You look at this and you have pretty well discredited Mr. Diffenbaugh's report, and you say there is no criminal conduct. I look at this report and I say there is. Now, the way to resolve this, wouldn't you agree with me, sir, is to convene a grand jury, get a prosecutor who is not beholden to anybody with subpoena powers, and if nothing's been done, let these people clear their good name. If there has been criminal conduct, if the taxpayers' money has been squandered the way I believe it has, then let the criminal penalties fall. Wouldn't you agree with that? That's the way to resolve this?
no, I agree that, you know, attorneys will disagree and look at something differently. I mean.
You don't see any criminal conduct, I do. So let's get a third party, a grand jury, with a good prosecutor to interview this, look at it, subpoena power, get it all up there, make a decision.
And I did indicate earlier that, yeah, if there's something criminal, it's for the district attorney to review and look at.
And you've discredited, and I understand, you were hired by Gilbert to begin with. And I understand where you are and where you're coming from. And I understand what you've been tasked to do.
Okay.
But I disagree with you. And I think the thing to do to get this is taxpayers' money. This is my money. This is your money if you come in here. I don't want it abused and mistreated. I think people ought to get value for their dollar. And I think it's readily apparent, even you would say, that people haven't got value for their dollar in this deal, have they? Would you agree with that?
I would say that, you know, they have gotten value. Have some of them been, you know,
There has been
you didn't get your bang for the buck, no.
There has been an awful lot of money squandered, and that's putting the best face on it. Wouldn't you agree with that?
There's been money expended in some of the
Squandered.
some of the projects.
Expended. I said squandered.
And some projects haven't, you know, lived up to, you know, how they were billed, or you didn't get the marketing that you wanted. But sometimes promotional activity, it takes 2 or 3 years for that to see results.
Hardly ever.
The taxpayers of this community over the past 20, 25 years spent $25 to $30 million. We ought to have Silicon Valley here, and what have we got? Not much.
I'm not sure where that number comes from.
Yeah,
It comes from a
Well, it's $12.5 million, $250,000 a year. Okay, for 10 years, that's $12.5 million. For 20, that's $25 million.
Ms. Barrington, is it 21 million, the total income that has been received by the PEDC?
Okay, 21 million.
Okay.
The
That
spreadsheet.
is one heck of a lot of money. That has not, we don't have $21 million to show for it. Wouldn't you agree with that, Mr. Moore?
I can't speak to that. I was asked, I mean, all the projects you've done over the lifetime of the sales tax, I have not looked at all those expenditures.
Well, the spreadsheet that I have indicates that it evidently does come to 35 million. I mean, I've got it in black and white.
Yeah, I'm not
And
gonna
where did
doubt
I
that.
get it? I got it from
Where-
PEDC.
How much did you say?
35 million.
35 million.
That's right.
How can we only receive 21 million and you
I'm
keep
going by
saying
your
30?
own records. That's your own records. I didn't make them up.
What I would add, I mean, the sales tax, if
Total receipts is around $21 million since the inception. First year was 600,000, and it's been since then.
Well, I can submit that.
Yeah,
to
imagine the
anybody.
comptroller's office could provide that answer.
I think there are some grants they pursued might be involved, but it didn't look like it to me. But I've got those figures, and they came from PEDC.
I mean, I would add, I mean, the sales tax, if a tax can be popular, this one is it. Type A, Type B, there's about 600 cities that have one or the other. You just have to look at City of Dallas versus City of Arlington. You know, Arlington has Dallas Cowboy Stadium. They have the ballpark in Arlington. Why? Because they had a Type B sales tax. Whereas, Dallas, they have a penny going to mass transit and a penny for the general municipal. City of Frisco versus City of Plano. Plano has a 1 cent general municipal. They got 1 cent for DART. And Frisco has type A, type B.
And that's all well and good if the money is used properly, if it's not squandered, if it's properly oversight.
We don't have any of those things to show.
But it hasn't worked here.
We don't have any of those things to show here. I mean, those are wonderful, and I'd love for them to be
That's
here.
absolutely true. I agree with you completely. And it falls on the city council. They're the ones to blame because they're the ones that decide who to put on the PEDC. And it's obvious that we have done a crappy job putting people on the PEDC over the years. And if anybody's to blame, we need to look in the mirror. Look who you put on the board.
Mr. Moore, I'd have a question. I mean, would you say this is an unusual situation? I mean, not this circus, but the fact that our PEDC doesn't have a lot of success stories to sell. In fact, really, through the previous, 3 or 4 directors, they weren't very successful at all, but that's not uncommon. We're all competing against multiple cities, both in-state and out-of-state. So you're very lucky when you attract Kimberly Clark or a Campbell Soup, and those were done without the aid of a PEDC by good citizens who worked hard to make those deals come true. But again, most cities believe that an EDC is a useful function, but we have a cabal of people who've banded together to try to decide that we should vote that out, and I'm not certain that that's right. In fact, Mr. Gilbert is the one being accused of all this wrongdoing, yet his was the most successful PEDC we've had, and he actually got award. Well, he got an award winning. They were award winning. They received a national attention as being one of the most successful PEDCs. So whether they squandered money or not, they spent money, but they also got some results, which is more than our previous directors had. So I'm not defending Steve Gilbert per se, but he hasn't been given the chance to speak. So
where is he?
He refused to be
Well, you've already
interviewed.
fired
I'm
him.
sorry.
I would just add,
We didn't fire him, he quit.
Ladies and gentlemen, if we could draw it back to the agenda item at this point, and I understand discussion's part of that, but does anybody have questions specifically for Mr. Moore about this?
I have one. I have a
Mr.
question. In your opinion, is there not enough written procedure stuff for the PEDC right now?
I think there is. I mean, state law's already addressed all of it, except maybe travel policy, maybe, per diem expenditures. But as council, you get to appoint the board members, you get to approve expenditures. I mean, so there's that level of oversight already. So to say you need a lot of oversight, no, state law's already do you need a lot of policies? The answer is no. You've already got state statutes that address, expenditures and the approval.
Mr. Frierson, can I ask another question?
Sure.
Are you done, Mr. Plata?
Yeah, go ahead.
Okay. Mr. Moore, one other question that I had for you is, you said that you obviously need agreements. There was another project which was brought over, which is the LG project. I don't remember exactly what the name of that project was, in which I think we gave about $100,000.
Okay.
And they were supposed to give the money back to us in case the project didn't materialize. The project didn't materialize. The $100,000 was gone. I'm not sure. Ms. Sharon, did any money come back out of that?
I didn't understand the statement.
Okay. What my question was, you remember the LG project that we were planning to do?
The LG project?
Algae.
Yes. And so the problem that happened with that was that we gave $100,000. The project never came to fruition. And that can happen. But the thing is, part of the deal was that if it didn't come to fruition, that they'll give the money back to us, because that was being used for some study or whatever. The problem that happens, though, is that when you have rules that say that you have to have an agreement, and the agreement is not done, what is the shortfall? What is the fallback for council, EDC, citizens, or whosoever? What do you do then? I mean, you're saying that none of it is criminal, okay? None of it is criminal. None of it is fraudulent, okay? It's not fraudulent. what happens if taxpayer funds are wasted like that? And if it is somebody's fault that the agreement didn't get done?
Well, I mean.
So what I want to know is, what is your recourse on it?
Well, I mean, for businesses that don't follow through with, what they promised to do, I mean, you always have the remedy of filing suit against that
And I
business.
understand, but the problem was not that. The problem is when we ourselves don't get the contract signed, then where do we go with it? Is there a recourse? Supposing I'm the EDC director, okay, and you're saying that I need to have a contract with the company to give them the funds, okay? Well, I didn't get the contract done, and I gave them the money.
But you couldn't give it without other people's signature, right?
Can I just finish?
But isn't that correct?
Can I finish the
Yeah,
question?
but that's what you're saying is not what happened.
Sir,
My
can
question is,
I'm not done with my question.
Okay,
I'm asking.
then
You
ask
can
it correctly.
yeah. Well, I'm asking the way I want to ask it.
know.
You know?
then be honest.
Well, what do you think? I'm dishonest in asking the question? I'm asking a straightforward question. He has said that you don't have a recourse, and I'm asking him if the person who's supposed to do what he's supposed to do, if I'm the EDC director, I don't get the contract signed, do any of them hold me responsible for it or not? Do they have any recourse against me or not? It's a very simple, straightforward question. I'm not asking a complicated question.
That's a political issue. I mean,
I want to know, why is it a political issue? I think that the money is spent
for not carrying out their duties.
Yes, and that is what I'm saying. So is there no recourse in law that if somebody does that, I know you can be fired for that, but is there no recourse in law that, what do you do if somebody does that? I mean, if Mr. Anderson starts, or let's say Mr. Anderson is not in a position, but supposing the city manager starts spending those monies or signs the contract for doing the road, but actually doesn't sign the contract but gives the money, what is the recourse? What do we do afterwards?
Courts, what they've done is they prohibit future impermissible expenditures. If a taxpayer brought suit, let's say there was going to be another expenditure made to algae, then a court could, enjoin that, that payment from being made. It'd be future expenditures that the court could, prohibit.
But there is no recourse against the individual who's done well, I don't want to use the word crime because, as you said, it may not be a crime, but it's, misuse, and not following through the procedure. What is the recourse? Is there no recourse? Let's say we may consider 100,000 as a small amount, though it's not a small amount, but let's say it's a small amount. The City Council has authorized PEDC to spend up to $400,000. Tomorrow, the EDC director gives $400,000 to somebody. Even though Mr. Frierson and me and all of us signed that, okay, well, it's okay to give, but he doesn't have a contract. I don't think in the course of every day, me or Mr. Frierson or any one of us go and look, okay, Mr. Whosoever, where is the contract? City manager, show me the contract, where is the contract? What happens then? I mean, how does one recover funds, or how does make a person be punishable for that? And I'll give you an example. Let me just say one other thing on this. Let me give you an example. What happened recently in the town was Janice's office had an issue. There was an individual who kind of pocketed some money, and the amount was $2,000 or something like that. But that person went to jail for that. And I mean, I just think it is kind of sad that you will punish somebody for $2,000, but here somebody spends $100,000 in the city or PEDC, or none of us have any recourse to do it. And please don't take me wrong. This is not about Steve Gilbert or anybody else. This is a question that, supposing it happens in future, again, that nobody has signed the contract, what do we do? How do we get our money back? How do we punish the individual? Or we don't punish and we say, okay, well, you know what? The law says that it's acceptable to get away with it. I mean, is that what the law says?
For the $2,000 example, I mean, that person personally benefited or gained from they meant to keep that money. And so that, penal code has theft statutes that address those sort of theft of, public funds. As far as the 400,000, I would say you change the policy on what requires council expenditure, that perhaps you lower that amount, that, 400 isn't just going out the door, and that furthermore, there needs to be written agreements. Written agreements approved by the board, approved by city council. And that would, I think, remedy that example.
Okay.
But there would still be no criminal activity.
Not if,
Aren't we guilty as city council for allowing it to happen in the first place?
I'm sure we are.
the city council has an oversight, and you get to exercise as much or as little as you want. So, yes, as council, you get to appoint the members and you get to approve the expenditures. But there's not a criminal penalty for that example. Because they weren't trying to personally benefit from that.
Well,
Just for clarity, though.
But that means the taxpayer just winds up with it in the neck again. There's just too many examples like this.
Well, then, I would clean up the approval process, and that's one of the recommendations, the approval, and then make sure you have written agreements.
Right, well, for instance, in a tax abatement, I know of an instance where not one job was performed, but a goodly sum of money went ahead and passed hands. And that particular business has not met their obligations yet. I mean, where do we get control of this thing?
You may have a written agreement that provides the recourse of the penalty under the tax abatement. I would add, in the initial final report, there was a mention of tax abatements, that the EDC can't do tax abatements, which is true. They can't do a tax abatement. Chapter 312 of the tax code, tax abatement.
They can't give them, and should they also not enforce them? Should somebody else be enforcing them?
Well, yeah, they can't do it. A city can enter into a Chapter 312 tax abatement agreement. EDC does not have the authority. But I've done a number of agreements where it becomes the economic equivalent of a tax abatement.
So incentives are not allowed?
No, you can do incentives. What I saw in the preliminary report, it said, the PEDC did tax abatement agreements. Well, it might be, the economic effect may be a tax abatement agreement, but the way I've usually structured them is, developer, you're going to put in a street, water and sewer for this business, get us the invoices and receipts for that infrastructure, and we'll reimburse you the sales tax you generated. And so that could be seen as a tax abatement.
This is more of a promise of hiring people, a certain number of people, and yet before even one person was hired, that amount of money was already given to the entity. And I was shocked when I read that.
Well, council would have approved that agreement.
I don't think they did, and maybe that's certainly something.
And I would always do it, on a reimbursement basis, or you generate the jobs, and then we'll
Absolutely,
we'll give you.
that would be a reasonable way to do it. This didn't happen that way.
Okay.
Mr. Wilson?
In this instance that Dr. Hoshby is talking about, there was the director, which he's saying should be held accountable because he gave the money out and it didn't get the pan out. Okay, then is there any the board, the PEDC board, should have reprimanded and demanded something from the EDC director, Mr. Gilbert? Did anybody give him a job performance, or did anyone reprimand him, or did anyone place these issues in his personnel file?
I did not review. I didn't
That's
review
what
any of that,
I'm
but
asking. There is it was all brought up. This was been going on for a year. Ms. Clifford, did you ever call Mr. Gilbert in? Did you reprimand him? Did you fire him? Did you put anything in his personnel file? Did you have a performance review with Mr. Gilbert?
All these things were done before I got on the board, the algae agreement, the HWH agreement, the incubator, and it stopped. And we did put policies and procedures to limit the amount of travel expenses, because when he stopped, where you could go and had to stay at a Howard Johnson's, he'd go to Las Vegas and stay at the Wynn, or whatever the high costs were. We stopped that when I came on board. I cannot take credit or whatever for prior board, what they did. Only didn't know
But
what happened.
when you discovered this, did you put anything in his, in other words,
I
why
didn't.
didn't we fire him when you came on board? Why didn't you reprimand him or?
Very simple, because she didn't realize what was going on until we got into the Diffenbaugh report, Mr. Wilson. We go in here, we're going along, we see this, we stop the incubator, because it's obviously a sinkhole where money's going. We stop, we get in, we get the Diffenbaugh report, and that's when we figured out when all this was going on. We didn't know last year. I was on the board too.
And
Just like when you came on, you didn't know what was going on. You still don't know what's going on because you haven't been here for 2 months.
For instance, on the incubator, I asked for a contract. I was given a contract. It was handed to me, here's your contract. And not until I was talking to other parties to that contract did I find it was not signed. He implied it was signed. So maybe I should, but I can't fire him on my own. We did not have the votes to fire him. He quit, and Mr. Grossnickel, or Dr. Grossnickel, he quit. We did not fire him. We limited what he could do and what he could spend. We took the credit cards away. We are limited the amount of credit card expenditures.
You say you couldn't fire him or anything, but you apparently, if that was a concern, you knew it then.
I expressed all the concern.
But you did not put it in his personnel file or do anything.
Neither did I. So I'll take part of that credit. Don't
Okay.
start jumping on her. Like I told you a while ago, Mr. Wilson, we came
Folks,
on
let me
board,
interject
we
here real
started
quick.
looking at this.
Mr.
It
Turner.
didn't become apparent what's happened until after he had quit.
Mr. Turner.
When he knew what was coming.
Can I interject something? We're professionals up here. Let's treat each other
No,
with
we're
dignity
not.
and respect. So I do have one question I wanted to ask, and you said something that I caught, but I want to make sure I heard it correctly. And when I read the Diffenbaugh report, I read the allegations of fraud and waste and abuse, and then there was things in there about possible ethics violations, and I really think he was kind of centering in on that HWH issue when he was mentioning that. And I think the whole issue there was a non-disclosure form. Did you say earlier that you did see a copy of that non-disclosure form?
Yeah, there's I think it was August 23rd of 2010, there's a disclosure questionnaire filled out by Mr. Barrett.
So it was just obviously
Mr.
something
Beard,
Mr.
excuse me.
Diffenbaugh didn't discover in his investigation.
Well, I think that was provided to him, to Mr. Diffenbaugh, after the initial final report.
After the preliminary, but before the final, so he didn't change
Correct.
the final report to reflect that, though.
I think it was provided in between the, if I got my timeline right, it was provided after what we thought was the initial final report.
But if he had simply asked questions and investigated, he did not call the city, he did not call anyone and find out if there was a conflict of interest statement available, okay? That's the problem with this report, is he failed to investigate. He took whatever was given to him by Mrs. Clifford and others and made his report, his first report off of that. The report that he has not given this board as of tonight. We still do not have the report that he turned over to the FBI as of tonight. We've asked for it. We're withholding his payment. But he has not turned that over to that. Is that correct?
I haven't seen
When was the last time you talked to him and asked him for this?
it. Was last week, about the middle part of last week.
Again,
Well, there are also
So-
a lot of people who refuse to be interviewed.
after
Pertinent people.
2 months after he turned his report in, did he make his first call for an interview. And that's because it was brought up in the questioning is, hey, how did he come up with all this and has not interviewed anyone? In
Mr.
fact,
can I ask one more
there
question? I'm sorry.
Just one second.
Sorry.
Mr. Wilson.
There is, well, go ahead.
I'm sorry to interrupt. Again, I have a little question on conflict of interest based
Okay.
on what you had said. And again, Mr. Wilson, please don't take me wrong. I do respect you, whatever anyone might think, because I think you're a smart individual. I've asked you questions on the budget, but I did have a little concern which I want you to address to me, please. At points, I have felt that Mr. Wilson had conflict of interest, particularly when things of the incubator were being discussed because of his association. And I'm not going to go into details of what the association was. Is that not applicable here? Is it whether the association with the company that he may have had some connections to, or he has something in the incubator that makes him, at least to my mind, conflict of interest? Do those rules not apply to board members of PEDC like they would to me and Mr. Pickle and all of us?
Dr. Hoshby,
Yes, sir.
was I on the PEDC board when the incubator was going
No,
on?
that's not my question, Mr. Wilson. That's not what I said.
How did I have a conflict of interest?
Okay. You
with-
don't have a conflict of interest then. I'm asking, is this a conflict of interest now that if the PEDC is investigating a company or is investigating RB3I, does he have a conflict or he does not go by the same rules as all of us, is the question. Because to my mind, as you said yourself, that it's not a question of just voting on a subject, it's a question of even discussing the matter. And that is my question, that his discussion might influence my judgment. Does that come into this conflict of interest, or is he not governed by the same rules of conflict of interest as council members?
Yes, state law provides that it applies to local or public officials. And the Attorney General opinion has concluded that that state statute on conflicts of interest does not apply to type A board members. I understand that it's been imposed locally, but state law does not impose that, requirement of the conflicts of interest.
I still do not understand how I have a conflict of interest with, are you saying that I can't even sit here and have a discussion because part of Deffenbaugh's report covers the R3BI? Is that what you're saying?
That's not what I'm saying. That's what your city law says. That's not what I'm saying. He's telling us that the state law does not say that, and you don't have it. You don't have a conflict of interest.
How do I have a conflict of interest?
Well, he just said that if you are discussing a matter, it's not just the voting, it's the discussion of a matter in which you may have an interest is a conflict of interest.
When that matters before the board or council. So if you were voting on the R3BI contract,
Yes.
those that have a substantial interest in R3BI, that would be 10%, usually it's 10% or more of your gross income.
Which I do not.
Then you have to file an affidavit, abstain from voting and discussing it. It uses the term further deliberation, which hasn't really been, there hasn't been court cases that really address what's further deliberation. There's an Attorney General opinion out there that touched upon it, that noted, does that mean you can't go into the executive session even though if you sit there quietly, don't say a word? Is that further participation? And they said maybe the better practice is to stay out of that executive session. Even
That's what I
even if you
was
sit
asking.
there quietly. But here the issue is the report. You're not taking action on R3BI.
Okay. My second question is...
Wait just a minute.
Yes, sure.
My conflict of interest, apparently from what you're saying, is that my son served at some period of time on the R3BI. And is that what you're saying my conflict of interest is?
That is what I'm saying, your conflict.
All right. I'm serving on one board. I was not serving on this board. I had nothing to do with this board when my son served on the R3BI, okay?
Okay.
But
He's saying now that I can't even discuss this or have anything to do with this because that back then that I have
Is your son still on that board?
No.
Is it?
it's dissolved.
It's usually your
is.
10% of your gross income. I mean,
I have-
so for the
I have-
prior year, so that's not a
gets no
conflict of
income
interest.
Okay, well, then the answer should be that there is no conflict of interest. There is no argument
Yeah.
about it. It's a simple
Okay.
question and requires a simple answer.
And are you satisfied that I have no conflict of interest?
I will reserve my opinion because this is one attorney's opinion. And I respect what you're saying. I'm not going to get into an argument here with you. Now, I will have one other question with reference to this. Mr. Pickle owns a printing press.
Printing
Okay?
company.
Okay, printing company.
Several presses.
Oh my God. Okay, printing company. Okay. And tomorrow he decides that he wants to print something for the city. The city, while he is the city councilman, can he just sign the conflict of interest form and say that I have a conflict of interest and then continue to publish? Is that okay or not?
Well, if that contract on the printing company was coming in front of the council, then he would have to file an affidavit, the same from voting and discussing it, and the rest of the council take up the matter.
Okay, so he will have to excuse himself for that.
Yeah.
But he is allowed to do business with the city.
I'm a-
City ordinances, I can't.
I realize that. I'm talking about the state law that he's talking about.
I'm assuming he's deriving 10% or more of his gross income from the company.
From the
you know.
city?
No, not.
No, from the company.
Yes.
Yeah, from the company. So
Yes.
if you meet
That's a good assumption.
if the definition of
Very interesting.
substantial interest in that business entity, then, yeah, one should file an affidavit, abstain from voting and discussing it. The rest of the council take up the matter.
Okay.
Am I
he-
doing that?
No, you're not doing it.
Okay, well, I thought maybe I missed something.
Well, I thought the whole thing is about exercise to learn the issues that we've had and corrections of those issues. So when you have a gentleman who can give you an answer, there's nothing wrong in
No, I
asking.
just didn't know it.
I'm not accusing you that you are.
Because I don't at all,
I realize that. I know that. So,
unless it's free.
okay.
No, I'm good.
Mr. Moore, I do
Yes,
just
Mayor.
have one question just to kind
Yes,
of
sir.
reiterate. For me, the takeaway out of this is that the oversight needed to be improved, and the steps that have been taken over the last year should tighten those up. Outside of that, is there any areas of concern? I mean, I know that Rebecca and the rest of the board has been very active in limiting their not only travel expenses, but also the individual
Yeah,
expenses.
if you have the board, approving the projects or expenditures and the council approving it, and you have written agreements, I think that's your issue. And that oversight, I think, would resolve the issues that you have.
Okay, and to that, I would just like to direct it back towards the EDC board. Can you guys move through these issues, not necessarily individually, but just to kind of give an overview of the steps you've taken in the past year to address the issues and recommendations that were laid out in the report?
Sure. I wish I could say that I had a big role to play in this. I did not. I think it was Rebecca and Mr. Bruce Carr, when he was on the PEDC. They realized the need and the opportunity to improve processes and procedures. So they began to work, I guess it was about a year ago, and to date have identified, drafted, reviewed, and approved 16 policies and procedures. These policies and procedures include authorized spending levels, credit card use, travel, entertainment, delegation of authority, procurement of services and contracts, and so forth. So I think they've done a really good job of identifying opportunities to put meaningful controls in place, and have passed these policies through the board to do this. So now it's our job as a board to exercise our fiduciary responsibility and make sure that we're doing these things going forward.
Thank
Does
you.
that help?
Yes,
Okay.
I think so.
Can
Any
I
other
ask one more
questions?
question?
Yes.
Or any more actions that the council decides to take, or the PEDC decides to take, or anyone out there decides to take, would have to go through the district attorney. Is that what you're saying?
As far as any criminal, if you thought there was any need for criminal investigation, it'd be with the district attorney's office.
Okay, but if
Comptroller and AG's, Attorney General's office does not have oversight.
But if it was a civil, we're whistling Dixie.
Civil matter, I mean, if, you pursue civil action against a business for non-performance under an agreement, I mean, you could take those sort of civil actions, correct?
But we would go to the district attorney, then he would decide if it goes to the AG's office. Is that correct?
Like for areas like open meetings, or, there's some areas where the AG's office has, level of expertise, where maybe in some rural areas where, the DA's office doesn't have
But things
certain
like we've been discussing here tonight, if it was turned over to the DA, would he then try
Yeah, I think the DA could look at those issues. I don't know if they would necessarily need to go to the Attorney General's office. But the Attorney General's office does have a prosecutor's assistance division
Okay, yeah.
that can assist
Well,
with certain
because this
matters.
was mentioned that take it to the grand jury and all this blah, blah, blah stuff. Well, and I understand that there are, for every, attorneys are like other things, everybody has a different opinion or whatever. Anyway, although I will say, it goes back to, if you were going to have heart surgery, you would want a heart expert. You wouldn't go to a family doctor. If you wanted economic development things, you would go to an expert and not to a general practitioner. The reason I bring this up is because the economic development handbook that was written last year acknowledges in it the people that were responsible for putting it together. And one of those people, it says, this publication was developed in substantial assistance from many sources inside and outside the Office of the Attorney General. The Office of the Attorney General would like to specifically recognize the following people and organizations. And it lists several, last of which, I guess because you're a T-SIP, is Attorney at Law Jeff Moore. So I understand that you may think something's different, then he thinks something different, then he thinks something's different. However, I would think that he is probably the expert in the matter versus anyone else in here.
Ask him how many criminal cases he's tried in the last year.
I'm asking you, how many economic development cases have you been involved in the past year?
None, and that's
Okay,
not
that's
the
my
issue.
point.
It's
Thank you.
whether it's criminal or not.
And he said it wasn't.
And I say it is. I'm asking you, how many criminal cases you tried in the last year, Mr. Moore?
10, 20?
Criminal cases?
Yes, sir.
What kind?
Class C misdemeanors.
Okay.
And municipal court.
Traffic ticket.
Correct.
How many murder cases you tried in the last 2 years?
Zero murders. I'm a
Well,
city.
I tried three.
I'm sorry.
From all the way up to murder.
My
Well, I think
practice has
we're
been
getting murdered around
city
here
attorney
right now,
work.
so I need an attorney.
I have a question.
Sue?
If you're seeking redress from the DA's office, but the DA may have some close ties to part of this investigation, where do you go from there?
That's where they may ask for, the Attorney General's assistance, perhaps.
Okay.
Or the DA could simply ask to be recused and bring in a visiting DA.
That's a possibility as well.
I have, please, one more question. Well, I meant that's what, I think people want more transparency. Is that the best way, is that the best thing we can do, that you talked over with transparency, that's the best thing we can do?
That's the best way to handle it. I mean, the records are, for the most part, open records. When you're in negotiations, they're going to be confidential. But yeah, they need to have written agreements. They're public once executed. The meetings need to, they're subject to the Open Meetings Act. So yeah, transparency helps.
Doesn't accountability also play into this?
Accountability helps. I mean, and moving.
Because it looks like we've lost a lot of money and nobody's going to be responsible for it.
But moving forward, you tighten up the policies to address,
I'm having a hard time moving
issues.
forward past 35 million. That just, I'm not a rich person. That's a lot of money.
Well, I think that's actually what Mr. Moore's already addressed, that as much as we all want to have success every time, I don't think this is the arena in economic development where you bat 1,000. I think this is one of those things that...
How about two?
Well, you could argue the points over and over, but I think the overriding theme is that what you're indicating is that we need to make sure that we're all on the same page, and that we're making sure that everyone knows, or that the left hand knows what the right hand's doing, and that everyone agrees with it, at least in the majority. And manage the best you can and be as productive as you can within those realms, if I'm not speaking too out of turn.
That's absolutely correct.
And if back to Dr. Hashmi's question, I think the other idea that comes back is tighten up the contracts, make sure the clawbacks are built in, and make sure that performance appraisals are done and employees are being held accountable for, and staff being held accountable for their actions, good, bad, or otherwise. So, I mean, outside of that, there aren't very many other choices.
No, I mean, just follow the state statute and you've addressed a lot of your issues.
Okay. Anyone else have any questions for Mr. Moore?
Not for Mr. Moore.
Okay.
I
Mr.
would
Brown?
like to make a motion that the PEDC recommend to the City Council that no further action be taken in this matter.
Ladies and gentlemen, if you could hold it down, thank you. Appreciate that.
All right, thank you, Mr. Brockman. The PEDC, excuse me, Mayor.
Clarify that. In other words, we've heard our report from Mr. Moore, and we don't see, it's up to the City Council. We're turning over the report to them.
Correct.
And saying, we've listened to it, we've seen the report, we've had a report from Mr. Moore, and it's up to the City Council to do with what they want to do with. We're not going to pursue any criminal action. Is that?
That's exactly what I meant.
Okay.
All right, so we have a motion
But
on the floor, sir.
Okay, you got a motion. Okay. I'll second that motion, but we'd got more discussion. Are we going to continue this meeting and have more discussion? Or is this the end with this meeting?
No, I'm open to that if the mayor is.
Discussion's still ongoing as far as I can
Okay.
tell.
Well-
So do we want to table that motion for the time being and come back to it?
That's fine.
You withdraw the motion
I'll
temporarily?
withdraw.
Okay.
Okay. Any further?
I'd like to say something. It seems to me that this has all been about punishment. It's not accountability, it's punishment. Find the bad guy who did this and collect money from him or sue him. But realistically, whether someone did something wrong or not, it's been approved by his board, their board, the city council. We spent $50,000, even though all the list of improvements in financial oversight that had been made by Ms. Clifford and the rest of the board that Mr. Grubbs just read, those had already been placed before the city council ordered this forensic audit, which at the time I don't think anyone really knew it would run $50,000. But it did. So $50,000 more has been spent, and we find that there's very little, there may have been mistakes and problems with accountability, but they weren't necessarily illegal. So let's move forward, as Mr. Moore suggested, and I don't see any point in trying to pursue a legal action unless it's against, for example, the algae company. Surely there was some degree of a contract, even if it wasn't signed, but the man has $100,000 of our taxpayers' money. If you want to pursue a civil case against that company, I'm all for that. But as far as the money that's been spent by the PEDC for the past 20 years, we can't get it back. It's gone. And we can, if the citizens are for doing away with the PEDC, that is their right. But there's a big orchestrated campaign going on to make the citizens feel this way. And I think that if you look back at the people responsible, they're the ones constantly on the radio, the TV, Channel 8 News. They're the ones that hang around after our meetings when we had a 4.5-hour meeting and we're all dog tired, and they're out here pumping hands and talking with Mr. Richards and the Paris people. So, look at who's telling you what to believe and think about it. And that's all I've got to say. I think we should, if we expend any more money on this, it should be toward recovering money that is recoverable. But the incubator shut down. I don't know how much money they got in a bank account. It's news to me that they had any. But if there is money there, we could try to get that back and return it to the PEDC. But other than that, I don't see much recourse at this point, or punishment. So that's all I've got to say. Thank you.
The main thing I think we're looking at is to make sure these things don't continue. When you're talking about the 100,000 algae, I can tell you I've got a lot more money than that. And the citizens are due our due diligence. They've invested in trying to improve our future. And I make no apology about going on the radio or shaking hands or trying to get my point of view over. I'm backed up by fact, and I'll stand on it and I can show anybody. So I'm sorry. It is what it is. We can't whitewash this. It's a shame.
But are you willing to take responsibility as well?
Well, of course. And you start trotting these things out, I'll be glad to look at their expenditures, and I've brought them. No, wait a minute, I didn't interrupt you. I didn't interrupt you.
I asked you a question.
I'm not through. Well, I'm answering the question. I'm sorry, but that's just the way it is, Mr. Pickle.
Go ahead.
I brought up exactly another expenditure that I thought was ill-advised. Current, $1,000 for a breakfast, okay? Mr. Moore and I disagree about what that money is for. We felt like it was to bring jobs. That's not going to bring any jobs. I would like to look at all of that. I'm sorry, I would. I think it's a shame nobody has looked.
That's the responsibility of the PEDC board, which is what Mr. Grubbs
Well,
just said.
he's making it my responsibility, so, okay.
Well, Ms. Lancaster, you've had that opportunity every time we voted to approve the actions and the budgets by the PEDC.
Well, I'm certainly going to be taking a lot more, longer
As well
look.
as the members of the
As well you
PEDC.
should.
And I'm still going to say what I think. After this many years, I don't see this as a positive organization.
And you're certainly entitled to your opinion, and
That's
we
true,
appreciate
I am.
that. Any other discussion?
Well, it's obvious that, this is an organized and orchestrated to discredit PEDC. In fact,
Ladies and gentlemen, one more
let me-
time,
let
I'll
me-
ask
let me-
you,
let me
please,
just-
we do
let
have a
me
public
say,
meeting going.
Let's go back and find out about this, starting this whole investigation off anonymous letter. You know,
Mr. Frierson, can I address that, please? Sure. Okay. I have a prepared statement that I want to say. Ladies and gentlemen, I had some reservations about coming to the meeting when Mr. Deffenbach was not present, but I felt compelled to come since there was a lot of misinformation going around and I wanted to clarify it. First and foremost, I want to say that I have not had any meeting or contact with Mr. Deffenbach of any sort. I received the anonymous letter in January or early February, at which time I told the city manager about it, the mayor pro tem Mr. Wright about it, since he's the one who puts things on the agenda. I asked Ms. Cleon Drake, since she had prior law enforcement experience, as to who investigates these kinds of things. She did not know, but she said that she will ask her husband. Later on, her husband informed that he found 2 companies that did it and that he can arrange for them to meet with me, to which I said no, since the council had not met and no decision had been made by the council as to what direction they want to proceed. Also, 3 to 4 days later, which was in the middle of February, in the executive session, I handed sealed envelopes to all the city council members with the anonymous letter and the documentation that came along with it. I also informed the PEDC director, Ms. Rebecca Clifford, about it, and I also felt that I should inform Mr. Holland Harper, since there was some relationship to that company. And again, I'm not saying right or wrong, I'm just giving you the information. The anonymous letter was received in the month of January or early February and given to the council members in the executive session in February. It was subsequently placed on the regular agenda in the March meeting. At no time during this period did I or any of my family members met with Mr. Deffenbach or had any discussions with any of his associates. Not only at that, at no time after that did I meet Mr. Deffenbach, other than the one day that he showed up at my office, and I've already disclosed that to the council. I did not try to contact him or any other members of either the City Council or the PEDC board to suggest that Mr. Deffenbach should or should not be appointed for the investigation. This misinformation that I contacted him before I got the letter, or that in any way or form that I suggested his name to some of the council members or PEDC, that he was hired by me before the council voted on it is completely false, and I'm perfectly willing to say this under oath. I had absolutely no contact. I almost didn't even know his name till he showed up at my office. So if anyone says that I signed a contract with him, or I had prior information about him, or I had not received the letter and we had already appointed him, is a bunch of baloney. And I'm willing to say that under oath.
Is that the end of your statement?
Yeah, that's the end of my statement.
Okay.
Well, Mr. Deffenbaugh said that you said at the council meeting on June the 3rd or June the 6th, whenever it was, that you stated in that council meeting that you were only in that meeting 1 minute, and that you told him he could look at the written report that you had, and you left.
That is correct.
And Mr. Deffenbaugh, when we questioned him, he said that was not correct. He said, Mr. Deffenbaugh said that you were in and out of the meeting.
No, sir.
And that, hey, okay, well, I guess we got it. Mr. Deffenbaugh's not telling the truth.
That is exactly why I wanted Mr. Deffenbach
Is Mr.
here.
Deffenbaugh not telling the truth?
Listen, I'm not concerned whether he's telling the truth or not. I know one thing, that I'm telling the truth.
Oh, okay. And you also said that there was 3 people in the meeting. You were asked specifically by by Mayor Frierson.
Yes.
Was there, and you said, quote, there was 3 other people in the meeting.
Correct.
That is not right.
Well, I can tell you
Mr. Deffenbaugh said that it was Mrs. Clifford and Mr. Deffenbaugh and Mr. Deffenbaugh's assistant, Beverly something, and Mr. Strathern, which you did not say.
Okay, well, let me just tell you right now.
Wait just a minute.
No, I'm going to stop you right now, because when you make that kind of an accusation, I'm going to tell you right now. When I was in the room, Mr. Strathern was not in the room. And I walked out. I don't know at what point he entered the room, because I was seeing patients. And so if Mr. Deffenbach says that I had a discussion with him, it's absolutely a false statement. He asked me, what did I have to say? And I said, I have nothing to say other than what I've already said when I showed those receipts in the council meeting. And I'm willing to say that under oath, and that is why I wanted Mr. Deffenbach to be here. And I want to ask you one question, if that is the case. Mr. Deffenbach was not on the agenda, and I appreciate Mr. Grubb sending me a note today stating that I had questioned that his presence was not disclosed. I appreciate your note that you sent me, and that is from Mr. Moore's opinion. I'd ask Mr. Moore to please review the City of San Antonio 4th Courts of Appeals, 820 Southwest 2nd. Look at the Attorney General's opinion on that case, and then tell me whether or not the writing of Mr. Deffenbach's name on the agenda was required or not. That's number one. Number two, when we talk about openness, when we talk about transparency, when we talk about accountability, when we talk about working of City Council and City and PEDC together, Mr. Frierson was present at the meeting, Mr. Pickle was present at the meeting, Ms. Lancaster was there. Why were they not allowed to come into the meeting? What was so confidential that they could not, the 3 of them who are council members, who are actively involved in this discussion, and we are here today to put things together and move forward? Why were the 3 not allowed in? What was so hidden about it? And if that is the case, then explain to me. These are receipts from PEDC on the last expenses from Mr. Deffenbach. which were to be paid by you people. And that says final, I don't have it with me right now, but just a second. It says final report. There are charges on July 22nd, 23rd, and then there is a FedEx charge of final report sent to PEDC. Mr. Grubbs came over here, told us that was the final report. The next thing you know, it's not the final report. If that was not the final report, then where did the final report go? What were those charges for? Explain to me, what are those charges for? If those charges are not for the final report, then what were those charges for? And then, why is it that our council members are prevented? If it is Deffenbaugh coming, and if we are going to discuss the report, why should it be that the three who went actually to your meeting that day were prevented from going in?
So I'll try to answer that for you, Dr. Hashmi. An executive closed session is at our prerogative. And we have the right to do that. I'm not at liberty to talk about anything that was talked about in executive session, nor would I. We also have the option of not including ad hoc members. It can be board members only. And you respect that, being on the city council.
100% agree.
Yeah. So that was the decisions that were made. Again, I can't mention anything we talked about in that session. It was certainly for the board to consider. But
don't you think it makes us sitting outside a little bit concerned that here is Deffenbaugh coming. You have already come here and said this was the final report. And then 2 days later you find out, oh, this is not the final report.
Yeah,
the bill of the final report has been submitted.
And
and you may be right. I'm not saying you said anything wrong. I'm not saying you twisted his arm. But the question still comes to the mind that why such secrecy? Then on top of that, we are having a frank discussion, really. No hard feelings about it. You put down personnel, discussion on personnel, and I know you sent me the letter stating that while Mr. Moore has said we cannot disclose what was discussed in. Well, you know what? The City Council also discusses personnel issue. When we discuss personnel issue, we write it down on the agenda which personnel are being discussed. Now, there are only 2 personnel in PEDC right now. The deputy director and her assistant.
Yeah, and if I remember,
and Ms. Barentine said here that day that she was not present in that meeting.
No, she was not.
Okay, well, so she was not being discussed.
Well, again, I can't talk about what was discussed.
I'm not asking you to disclose.
But what I will say
is the discussion goes on for an hour and a half with Deffenbaugh and Mr. Moore in a closed session about 2 employees who didn't get a raise, who didn't get fired, who didn't get anything. What was the discussion about?
Well, again, and respect the privacy.
You don't have to answer.
And I can ask Mr. Moore to address what has to be on the agenda.
When you talk about working together, let's be honest and work together. If that is the intention of the PDC and the council, I have no problem with that. But let's be honest with each other and then honestly work with each other.
I agree with that, 1,000%.
There was actually 2 exceptions listed for the executive session. One was the personnel matter, listed out, I think, 2 positions, if I remember correctly. And then the other matter was consultation with attorney to receive legal advice. And I would say I was probably in there 45 minutes to an hour. For the first part, I sat out since it was personnel. But for the second part, I came in for the attorney-client consultation.
Thank you.
Thanks.
I'm not disputing and I'm not asking you to disclose. But you know something? You can ask our city attorney. Part of the reason why it was placed on the second time on the agenda, if you really want to know, is after I gave the anonymous letter in the council meeting, the city attorney found out. And how did he find out? The city manager told him. So the minute I came out, I was outside that door, and he said, what was the discussion? I said, there was no major discussion. I handed them an envelope, a sealed envelope. And he said, under what guidance did you order it? I said, well, I discussed it with the city manager, and we put it under PEDC because it was related to PEDC. He said, absolutely wrong. Correct me if I'm wrong. He said, absolutely wrong. You've got to correct it. And what is the correction? He said, you've got to put it on the agenda as a proper agenda item and fix the issue. And I said, no decision was made. You were not here, Ms. Lancaster was there, Dr. Grossnickel, Mr. Frierson, but no decision was made. He said, it doesn't matter whether the decision was made or not made. You've got to fix it. And the fixation that I did was I put it on the agenda as a proper agenda item. And so, as far as I'm concerned, this is honest to God truth. There is no conspiracy against Mr. You or him or anybody else. It's a matter of principle. And that's what we are discussing. It is not about individuals. It's not about me. I may argue with Mr. Pickle. I still, whenever somebody asks me, I say that he's one of the most hardworking council members. I disagree with him all the time. All the time. But I still
get right sooner or later.
No, but the thing about it is, I still acknowledge the fact that he works harder than a lot of other council members. Maybe not right now, but certainly when I worked with him before, he did. And so, if we want to move the city forward, if we want to get together, if we want to have a harmonious relationship, let's be honest with each other about it.
In this investigation that came out, okay, we've discussed it a lot tonight. What about those people that were harmed that was in this investigation that didn't get a chance, that Mr. Deffenbaugh didn't call them, didn't address them, or
and
anything.
You're 100% right about it. You're 100% right about it.
I'm not through talking.
Okay, I'm sorry.
Okay. The night that we had the anonymous letter presented, that very day, it was all about whether HWH received, and Mayor Hashmi sat up here and said, here's the accusations for this, and repeated over and over. We got a $5.8 million loan and $43,000 worth of collateral, all right? Now, that very day, before that meeting that night, there was, and he said, we don't have the information. That information was provided by Mrs. Barrington that there was $7.75 million worth of collateral. There was an appraisal that was brought to the city and given to the city. And yet, and Mrs. Lancaster, there's a video here if y'all want to play it, of what she said. Well, if should we give them time to come up and perhaps PEDC or HWH can bring this forward, and they can lay it out for us and put this to bed. So, and also, Mrs. Drake said the same thing, okay? And all the time, there was an appraisal in this building that showed and that answered their question and Dr. Hashmi's false accusation that there was only $43,000 worth of collateral. That he repeated what was in the anonymous letter, okay? And he moved forward even though that the city attorney was sitting there and let this entire conversation go forward without saying one word. He didn't say, I saw the appraisal today and that is not true, okay? Now then, I don't know if Dr. Hashmi told you not to give that appraisal that night. I don't have a clue whether he did or didn't, okay? I just know that that appraisal didn't come out to this council, okay? When did you get the appraisal that Mrs. Barrington?
Not until Jordan Harper.
So you never received that?
Made a ring-bound notebook containing all the particulars.
So you never received it?
No.
Ms. Clifford, you received it.
She emailed me, but I have a question about this appraisal.
Emailed this appraisal on the 12th 2 days after, way before you hired this thing. Now then, my point is that you slandered, and by the council slandered the Harrison Walker firm, and it was all over town. They got a set 5 point. It was even in the newspaper as a editorial on the 7th before you had the meeting, and announced it on the 10th. That Judy Battle wrote an editorial. The timeline is not there's something missing here. I cannot understand how you proceeded under false accusation with an anonymous letter that was not true, and yet you spent $50,000 or directed Mrs. Clifford to go out and hire an investigator that you'd already knew the outcome.
Don't say that.
Okay,
Don't say that, because I've already clarified that I didn't do it. That's number one. Now
Okay.
listen to this. If your time is up, I'm going to answer your question.
I'm
Do
gonna.
not make a false accusation that I prevented anyone from giving it. That's number one. I did not stop anyone from giving any documents to anyone. And you think that all these people are dummies, that I'll say that don't give it and they'll listen to me.
What?
Now listen, it's my turn to speak now. Number two, in any of my conversations, the first time the name of HWH was taken was by Dr. Grossnickel. I never said HWH at any point. Not once. And number two, I did not slander them. I said, this is a letter that we have received with documentation. And I never said this is true or not true. I don't know. If I knew that was true, why would I investigate? And number three, I didn't waste the $50,000. That's what you think, number one. Four people of this council voted for it to take it to PEDC. Don't forget that I'm not the one who appointed it. PEDC had every right to say no. Now you will say that I twisted PEDC's arm to vote for it? At some point you need to have a common sense and stop this nonsense.
Hey, I want.
It is nothing other than accusation after accusation after accusation, forgetting what the report says, but blaming me for something that you yourself very clearly know. You're a smart individual, you know money and you know business very well. And
I know you too.
Yeah, and you know it for a fact that that was wrong.
Mr. McKillier, I'd like for you to come forward.
Yes, sir.
You and I had the conversation in your office Friday, right?
You came by to see me Friday, that's correct? Mm-hmm.
My question is, why? You told Ms. Barrington that you were down there and first of all, I don't know why you went down there looking for this appraisal before the meeting. It would seem that you were trying to clear up this, and so we're not chasing a false accusation through an anonymous letter that there was appraisal there. Ms. Barrington showed you the appraisal, and I think she remembers that she gave you that appraisal and instructed her to make 9 more copies for the council. Is that a fair assessment?
Right. Ms. Barentine, when I first called her to ask her to double check with her when I saw that this was coming up on the council agenda on March 10th, I called her the week before to double check with her and see has she made sure that there's no appraisal reports related to this 2010 project. She was at a conference. She was out of town. Said the first time she'd be able to get with me would be Monday, which was the day of the council meeting.
Okay.
We also had a lot of other things going on that day. We had a smoking committee task force meeting that preceded the council meeting. I don't think I got those reports. I was over here in this building from 3:30 or 3 o'clock on through the council meeting.
Fair assessment. They were on your desk. Is that correct?
Right. She brought those to me.
But,
9 copies,
yes,
okay?
I don't know how many copies it was.
Well, now then,
But I did
but
inform
you-
the city council of that fact.
you knew what was you had seen the appraisal, right?
Yeah, it was like a 78-page appraisal.
Yeah.
I'm not an appraiser. I didn't try to verify whether it was accurate or not.
Okay, but
But
you knew
right.
that $43,000 wasn't correct. And you also went and looked at, you had copies, I think, of the tax appraisal, tax statements that added up to more than 5 million. Is that a fair assessment?
No, I don't know about that. I don't remember that.
Did you give a copy to him?
Give a copy of what?
Did, Ms. Barrington, did you give him a copy of tax appraisals as well?
Those that were ran that afternoon, yes.
Yeah, I don't remember that. I mean, that's,
My point being.
What is
that the point is that during this discussion, and I guess we ought to play the tape and let everybody listen to it. Mrs. Lancaster, Mrs. Drake, and Dr. Grossnickel all sat there in that meeting, and when they were going around, Dr. Hoshby let them speak. They all were concerned that shouldn't we ask HWH or shouldn't we get the PEDC and see if they can verify if this is all the value. And while they were having that discussion, and they were going to have you had the opportunity to say, hey, I know that there's an appraisal here, but not one time. And what I can't understand is why you did not.
Well, let me tell you why. There was the chief financial officer for HWH was sitting in this very room that night. I didn't feel like it was my business to tell the council whether HWH had an appraisal from 2010 when their CFO was sitting in this very room. So I didn't feel that was my business to do that. Now, I think Dr. Hashmi and other council members also made it clear that they were not just investigating an HWH agreement. They had concerns about financial impropriety, budgeting, booking, accounting. I mean, lots of things. So if I could do it all over again, Mr. Wilson, I would jump up and scream my head off. I don't think it would have changed the vote any, but I'd be happy to change that if I could go back in time and do that.
Why, when I asked you about whether you had discussed this with Dr. Hashmi, did he know? Why did you tell me that was attorney-client privilege and you couldn't say why you?
It is.
What you said.
That's because I have an oath with the state of Texas. My license depends on it. Anything I discuss with city council members, they're my client. I can't reveal to third parties. So.
Okay, can I ask you a question?
Yes.
Did you discuss that appraisal with any council member?
At what time? Well, yes, at
Prior
point.
Prior to the city council meeting, did you discuss the
Or
appraisal?
after?
Well, before.
Or after. After, I'm
No,
confident
I said before.
did. Before?
Before, did you discuss it with any council member?
I'm not going to breach that in open session. I'm not going to state that in open session. I'll go into executive session and answer your question. If that's
Okay,
what you want.
I'd like to move that we move into executive session.
Before we
If he doesn't answer that question,
Well, you can do it later.
I'd like to make a comment about this appraisal, if you don't mind. May I have, it's okay? I believe the appraisal question came up from an open records request that somebody asked if there's any documentation to support the $5.8 million loan guarantee.
Right.
I believe that's how the
whole
whole
thing
question of an appraisal came up. And at that point, when your office asked for that appraisal, Shannon said she was not aware of one. She emailed Mr. Gilbert. Mr. Gilbert said he was not aware of one.
Correct.
Then the appraisal, they did locate the appraisal, but at the time, neither one of them knew that there was an appraisal in process. But since this was a big part of the investigation, let's go back and look at that appraisal. The guarantee was for guaranteed collection of a $5.8 million loan. The collateral on the loan, the HWH offered their property located 1401 3rd Street in Paris. This is a direct quote from the appraisal. The property was appraised by Thompson Appraisal Services in Lindale, Texas. The bank had stipulated that they would only grant the loan if the property appraised for $6.7 million. The property appraised is $7.75. They also state that the listed property, which is 1401 3rd Street, on the 2010 Lamar County Appraisal District property valuation was $30,290. So we're being taxed at 3.9% of fair market value. That's my calculation. Then they further state that the review of the Lamar County website records for this property reflected unexplained variances. The appraised value of this property in 2007 was $1,106,800. In 2008, it was $1,118,670. In 2009, 10, and 11, the appraised value was a constant $43,970, and improvements in the amount of $1,096,700 were made to the property, which was reflected in 2007 and 2008 appraised value. However, these improvements were not reflected in any following years. The appraisal reflected the market value, again quoting, as is for all combined HWH properties located at or near the 1401 3rd Street tract and the buildings located thereon. Had all the HWH properties on this particular tract been combined on the appraisal district website, the amount would have resulted in a valuation of approximately $1.3 million, 16.77% of fair market value. The loan document and guarantee of collections were very specific that the appraisal was to be based on the property located at 1401 Southeast 3rd Street, not the entire complex. Even in the appraisal that was provided in the booklet by Mr. Harper, it said he lists out 9 different account numbers. The current assessed value of $1.322910 equates to only $5.05 per square foot. This is far below the estimated market value as is. Thus, it is an advantageous assessment for the owner. So,
Rebecca, just to clarify, what were you reading from there? You said it was an appraisal report, but it didn't sound like it was an appraisal report.
this was from the report.
What was the other book you were reading from?
This is the appraisal that
Okay.
Mr. Harper sent to all of us that he was referring to, the Rogers White. It's all public because he sent it to every board member, the current board member, some past board.
It was also in the minutes of the meeting at PEDC.
When?
Before the,
That's where I found the appraisal, wasn't
But it was not in the minutes, it was not referred to in the minutes on August 5th. It may have been in the booklet, but it was not.
it was in the minutes. You can
It
go
was
in there.
not
I
in-
went in there and looked at it Friday.
It was not in the copy of the minutes that I had. And I am not part of this, I'm just telling you what was written here.
Okay, but that has nothing to do with my question. Nobody argued,
Hey,
wait,
I would
wait,
like
the
my
thing was
property to be valued
the
at that
value was
price.
43,000.
Hey,
Okay, I'll make it
you
easy.
looked at
Let me
that
ask,
phrase.
let me ask
I'm
two
gonna
questions.
talk if I can.
Can I ask 2 questions real quick? Mr. Cecil and Mr. Amos, when you make a loan, do you make a loan based on tax valuations from the tax appraisal district? No. Do you make an appraisal based on a certified appraiser? Okay.
And
Again,
and
I would
that-
like to move
and
into executive session.
Wait a minute. What she just said is that we're sitting here looking at an appraiser that was selected. The bank has to go, they have 3 choices. They don't get to pick their appraiser.
I wasn't involved in the loan.
Why
I do
don't
not
you
know
address
any-
that, Mr. Brockman?
What was your point, Rebecca, that the property was undervalued on the tax roll?
Well, there's 2 points. One, that it's undervalued, but in the guarantee of collection, it only gives one of the properties. And in the appraisal, he used 9 properties, and that's in the Diffenbaugh
I think
report.
for
The loan.
simplicity, he didn't put 9 addresses on there. He listed the entire legal description of the 19 acres. But he listed
don't know. I haven't seen the
one
note.
address of, and that was the headquarters. That was the address that he put on there. But in the appraisal, he made it very specific that he was appraising 19-point-something acres.
That's correct, but I think in Mr. Diffenbaugh's report is that in the guarantee of collection, when it lists the collateral for our guarantee of collection, it only lists 1. It doesn't say the other 9. I am not the investigator. I did not look at it. I'm just telling you what is in the report.
Well,
Well,
the bank is collateralized with the 19 acres. They have the full amount.
Mr. Mayor, we seem to have deviated deeply from the agenda, and I would suggest that all this discussion is not covered under the agenda item.
We're discussing the investigation report.
Mayor, I know you have a motion to consider here, and I know the PEDC, guys, thanks so much for all your commentary tonight and for being so transparent in answering questions, but I want to go back, I guess, John, we had asked you to defer a motion earlier. Would you want to reconsider that?
Yes, I would like to make the motion that the PEDC.
There-
Go ahead.
There's one other thing that I would like to bring up. And it's addressing to Mrs. Clifford, who stood in this meeting, went to the board meeting and everything, and she said that she couldn't give a written report. Yet when we talked to Mr. Deffenbaugh said that, Rebecca, you told me not to give you a written report, okay? But in all
I'm
the
going to object to this. This is coming right out of that executive session that we're not supposed to talk about. Now, you know, if we're either going to talk about what went on in executive session, we're not.
Okay, I'll rest my case.
All right, so let's go back, Mr.
And the
Bachman.
executive session was supposed to be only about personnel. Obviously, whether there's a written report, that had deviated from the executive session then, right?
Yeah, and as you can tell, it's kind of hard to corral the cat sometimes. So sometimes we do vary, but we try to get back on track. And if you remember executive session, that's exactly what I did. I put us back on track. So, John, go ahead.
I'll make a motion that the PEDC recommend to the City Council that no further action be taken on the Deffenbaugh report.
All right, now, we have a motion on the floor.
Second it.
Mr. Wilson, second. Any further discussion?
I oppose the motion.
All in favor?
Aye.
Aye. Opposed?
No.
I'm opposed.
Okay.
Your own decision.
So, Mayor, it sounds like we're going to give this to you and the City Council.
So you turning your.
And I would, but if you would, let me just read something. And Dr. Hashmi, go back to what you said. We need a spirit of cooperation and honesty, and I am a full supporter of that. I do want to take offense to what Mr. Pickle said earlier. I do think that the most recent PEDC board members have been fine selections. But I did prepare something, and I want to read this before we adjourn. The PEDC was formed in 1993 and has a long history, largely driven by talented and committed men and women who gave selflessly and willingly in order to grow and develop business and industry in our great community over the years. Unfortunately, we continue to be distracted by unfounded and anonymous accusations and allegations that have caused us to waste countless hours and taxpayer dollars. In order to discover what we knew all along, and that is our PDC and our city is healthy and we're just. We need to work together. And we're not always perfect, and like many organizations, we're a work in progress, making needed improvements along the way. We are grateful to those who have worked and served in the PDC over the years, and now we are anxious to return to that work, the work that we've been charged with, to bring new investment, new jobs to our community. And I just look forward to working with this board to do that and with this city council. So with that said, thank you. Motion for adjournment?
So moved. Second.
All right, we have a motion and a second. All in favor?
Aye.
Aye. Thank you.
Thank you, Steve. Okay, back to our item. Mr. Pickle, I'm sorry you did have a motion on the floor, and the beauty and the curse of...
Is it legal for us to move into executive session at this point?
It's not really posted that way. I just noticed we don't have our normal posting on here.
All right, then I would ask for you come back up here, please.
I suppose we are adjourned.
Yes, we are.
Since we cannot go into executive session, and is there anyone up here that would not want to hear the answer to my question?
What's your
Would
question?
you repeat
My
it?
question is, did someone look at the appraisal and were they aware of the appraisal before the council meeting the night of March 10th?
I have no objection to that.
Did someone?
Did a council member?
Oh, did a council member? Did I show a council member the
that's-
report?
Did a council member have knowledge of an appraisal and the amount of the appraisal prior to the council meeting at 5:30 on March 10th, 2014?
I can't answer that. I don't know. I don't know if they did or not.
But you couldn't answer it a minute ago?
You asked a different question a minute ago.
Okay, what did I ask a minute ago?
What was asked a minute ago was whether I had specific conversations with any council members.
Okay, then I'll ask you this question.
About that. But I've already said I can't answer that in open session, Edwin. I can't do that.
This council wants to know. And so
But
if any
it
of us are
invol-
guilty, everybody here is all right with it.
No, but you're ignoring the fact that we had different council members as far back as March. That's what you're not taking into consideration. That are not sitting up here. We had other council members involved. And I can't violate my attorney-client privilege even to past council members in an open session. I'm not going to do that.
So you're insinuating that someone knew it then?
No, I'm not. I'm just saying I'm not going to answer that question if it involves former city council members or current city council members in open session. I'm not going to do that. Can't do that.
Even though this council is asking you to, and you work for this council?
I understand who I work for, but I told you there's at least 2 other council members that were on the council before that are no longer on this council. So I'm in a box.
So you can answer, why can you answer it in executive session and you can't answer it in public? When all the council's here?
Yeah. I could only address it as it applies to one council member that's on the current city council. And it's really not going to be as illuminating as you think it is.
Well, then answer the question.
No, I'm not going to, Edwin. I'm not going to answer it in open session. I'm not going to do that. If you want to bring it back at the next meeting and have it on executive session, we can talk about it. But I'm not going to do it in open session.
I would ask that the next meeting, we add 2 items to the executive session. Number 1, Mr. McKeever answer the question. Number 2, possible termination of the city attorney for failure to do his job.
Okay. Janice? Noted? Okay.
That's it.
All right. We have an action from the EDC. Is there any other discussion amongst the council at this time about this? Any action to be taken? If not, I'll call for...
So moved.
Got a motion to adjourn from Mr. Pickle. Second? Second from Dr. Hashmi. All those in favor say aye. Aye. Opposed? Motion carries.